welcome everyone to our webinar. Welcome particularly to Helen Barge and Anna Walters from Risk Evolves, who are going to talk to us today about privacy principles. Why does it matter? For me, it's always one of these things that sits in the fog that I know I should know more about. So I'm really looking forward to finding out some of the, probably the basics today, and then we're going to follow this with a more in-depth look and maybe a bit more of a panel discussion in about a month's time. So please join us for that. But just so that we're all on the same level, we're going to find out how it all works, particularly from the perspective of a health, safety, environment manager. I mean, this is something that I've been, and I know I've had huge issues with. You know, I'm used to the HSE accident book. Talking with my English hat on, where you ripped the page out and then said, "Oh, this data is secure." With the page with someone's name on it, but that no longer really happens. So how we keep that information secure now, what are the risks with holding that? You know, I know that people can ask for their data to be removed, and how I would go about with that, what data I would have to remove. But I'm from my side, I'm interested as what I have to do, but also when other people tell me what I have to do and actually understand if I really do have to do this. It's one, I mean, we from health and safety, we come from this background where we're told that we oversell things, and we go to people and we say, you have to do this, it's the law. And I feel that data security is even more like that. And I really would like the confidence to be able to say, no, that's not something that we have to do. So I'm hoping to get a bit of that out of it today. And these really are the two girls to talk to us about it. So Helen runs Risk Evolves Limited in UK, in the Midlands. And she apparently does all things risk, so privacy, ESG, health and safety, environment, and she said anything that moves business forwards, which sounds like a pretty good place to be. And just talking earlier, one of her phrases was resilient businesses bounce forward, which also is a nice way of looking at things. She's brought with her Anna Walters, who is the GDPR guru. Jedi even, not is a Jedi more than a guru, but she's the Jedi for this. So I'm looking forward to hearing her thoughts too. So I'll pass the microphone over to Helen and Anna, and thank you very much for joining us.
That's great, Alison. Thank you ever so much for that introduction, and hopefully we'll be able to answer some of those questions as we go through. Anna and I spend a lot of time talking about data privacy. It is a topic that we are quite passionate about, and we think it is one of those topics that is vastly misunderstood, and that misunderstanding leads to lots of myths, lots of uncertainty, and certainly lots of doubt. We would love this to be an interactive session, and I know that Julie's already pointed out the questions box in your GoToWebinar control panel. Please ask questions as we go through. There's no such thing as a silly question, so please ask questions as you go through. We'll try and answer some of them as we go through the slides at the appropriate point, and if not, we'll come back to them at the end. GDPR, yes, it's been around for a number of years, but believe it or not, it's a piece of legislation that is continuing to evolve as we get more case law coming through. We are looking at it from a European perspective, not just a UK perspective, so we'll try and answer any questions on that basis rather than looking at individual country perspectives. But without further ado, let's carry on, shall we? So let's just get this session going. Right. So a little bit about the IIRSM. For those of you that don't know about the IIRSM, we have got about 9,000 members across 95 different countries. And I know hopefully that everybody on this call is themselves a IIRSM member. If you haven't got any information about it, certainly pick up with Julie afterwards at the end of this call, or contact myself. I've been a fellow of the organisation now for a number of years, and I'm really passionate about how the organisation can help individuals develop their careers. So, Anna, big question of the day, what is data protection?
Gosh, Helen, I mean, you know, let's start with the simple piece actually, because I think one of the things I know that you and I find, Helen, everybody gets quite tied up in. Actually, data protection feels really complicated, you know, it feels very, very difficult, but I think it's really important at the beginning of a session to come back to the basics. And actually that's what this says in front of you. Data protection is purely a process of safeguarding important information, such as personal data, from threats such as theft, corruption, unauthorized access, compromise, or loss. And I think it's quite easy to lose focus sometimes and think that, well, we don't know what we're doing, but there's so many actions that we all take every day without even thinking about it that acts as data protection. So just as simple as locking your computer when you're walking away, or making sure that your phone has PIN access on it, or using multi-factor authentication. All those different steps are actually part of what data protection is all about. So we always like to kind of almost, Helen mentioned that there was lots of myths out there, and I like to just almost bust that myth, first off, to say, actually, while there's quite a lot to think about and do in terms of data protection, never lose sight of the fundamentals as to what it is. It is purely a process of safeguarding important information.
And what I like about this is we've got some really great and strong parallels to what goes on in the health and safety world, in so much as data protection is very similar to protecting the individuals that you've got in the workplace as well. So health and safety managers possibly coming into the world of data protection with just a culture and an ethos of how you look after and protect valuable assets. Obviously, health and safety is looking at valuable assets such as people. We're looking at information. So there's some really strong parallels. So without further ado, what's the data protection law then, Anna?
Okay, so there we go. Do you know what? I feel like there we go. Excellent. Okay, so the law is something slightly different. So data protection is the processes that we undertake to protect the data, but data protection law is something slightly different. It's all about safeguarding our rights and freedoms, and that's what's at its core. So the data protection law kind of sets the expectation as to how we should, and in parallel, kind of what Helen said with the parallels with health and safety. The data protection law sets the bar as to how to protect our rights and freedoms as individuals, and that's what we're going to talk about kind of on the next few slides. So just remember that actually the law is all about our rights and freedoms and the rights and freedoms of your employees and you yourself as an employee or as a consumer.
So why is it important? Let's go right back to basics, back to core principles.
And this is something that we talk about quite a lot, actually, because I think it's very easy to get lost in the why. And fundamentally, the reason why it's important is actually one of our human rights. We all have a number of human rights that are afforded to us, but the one specific to data protection comes from the European Convention of Human Rights, which is Article 8, and it is the right to respect for private and family life, otherwise known as the right to privacy. So fundamentally, there's quite a lot of the time people say to me, oh, but why should I do this? Why is it important? And when I mention the fact that it's related to our human rights and we all have a right to that privacy, I think it feels like it takes people back, doesn't it, Helen? And oh, okay. And it's surprising how many people are not aware of that fact, actually. It's one of those things, I think data protection has become that a little bit like health and safety, I would imagine, of it's like, oh, we have to do that. And actually, it's not about have to, it's about protecting people.
Perfect. So what is this data that we have to protect? We've got a huge list here. And I think it's really important to say that this is not an exhaustive list, is it, Anna?
No. And if Helen and I kind of discussed this slide before we came on, and it's always a bit, this list is not exhaustive. So nowadays, anything that can be used to identify somebody directly or indirectly can be classed as personal data. And we've just put a list here of, some of the more obvious ones. So, we know the name, date of birth, your address, your email address, phone number. Many of those can be used to identify you, but there's some more unusual ones, isn't there, Helen? So, for example, some of the more indirect ones, one that I quite like to use as an example is your car registration plate, because actually looking at it on its own, it wouldn't necessarily identify you as an individual. But once you put it together with, let's say, driving license data, or the government driving agency database, then it does become your personal data because you can be identified from it. And so if you think about it, let's think about it from a health and safety perspective. There's so much data that we collect that can be considered personal data. So it could be, you know, all that data from the accident book could potentially be considered personal data. You know, if you have data, let's say, if we go back, gosh, I was going to say a couple of years, but it's a bit longer now, Helen, isn't it? It's when we were collecting data at the beginning of COVID for vaccination or temperatures and those kind of things, that would also be considered personal data. So anything that relates to an individual can be classed as personal data. And I think there's also, oh, Helen, sorry, you were going to say something.
No, I was going to say, what about all this stuff that's there on the right-hand side, this special category stuff?
Yeah, so we've also got a more another category of personal data, which is special category data. And if we think about what's included in that, that's the data that if it was exposed and disclosed to somebody else, we might ourselves feel very uncomfortable about it. So this is things like your ethnic and racial origin, political opinions. It could be union memberships. It can be biometric data, so fingerprints, medical information, health information, information about sexual orientation. So all those things that are a little bit more sensitive, and those we should be affording those a higher protection to ensure that there's a much higher bar really when it comes to the level of protection that we should put in place around that kind of data.
And this is really important when we consider some of the systems that we may use in the workplace. So biometrics, perhaps to check in. I was at a car dealership a few weeks ago when they were using biometrics, fingerprints, to check in and check out car keys. So we just have to think a little bit about when some of these new pieces of data or these new systems are being brought in terms of what's the impact on the rights and freedoms of the individual. But we'll come on to that in a little bit more detail as we go through. So we've got some principles, haven't we, Anna, that are absolutely common across all the pieces of legislation that we certainly have in Europe. And just to be familiar with the legislation in Europe, certainly Europe at the moment is operating at a gold standard compared to many other countries in the world. It's a bit of a sweeping generalisation, but the European GDPR, the UK GDPR, some of the Swiss law that we've got is on a level which is probably more robust than we see in some other countries. So this is the gold standard that we're all aiming for. So those privacy principles, Anna, do you want to just take us through which each of those are?
Yeah, I will do. So, and I think I'll just add as well to that, Helen, that the reason that we're talking about these principles is that the GDPR is a principles-based law. So there are some laws out there that actually are very black and white and set rules. So you must do this, and they tell you how. Whereas the GDPR is slightly different and actually gives us an element of flexibility, and it tells us what we should do, but not necessarily how we should do it. So these 6 principles are the foundation of the European GDPR. So the first one, now I always think, Helen, that this one's a little bit of a con, isn't it? Because we talk about 6 principles, but I always think, well, there's 3 in this box, this first box. But this talks about making sure that when we are processing somebody's personal data, we should do it fairly, lawfully, and transparently. What on earth does that mean? So lawful and transparent are we're fairly comfortable with. So lawful, obviously, we're taking account of all the relevant laws. Transparent means that we're actually being honest about what we're doing with it and actually communicating with data subjects how their data is being processed. And we would usually do this within a privacy policy. So most, all organisations out there will have a privacy policy. Some make it available on their websites, and that is to meet the transparency regulations. But what does fairness mean? Fairness is really quite a tricky one to talk about, because fairness, what's fair to me might not be fair to Helen. What's fair to Helen might not feel fair to Alison. It's very much a personal judgment. And the way I always think about it, and I've been working in data protection for well over a decade now, and I always think about it, if somebody says to me, I want to do this with somebody's data, we all have that initial gut reaction that goes, oh, I'm not sure. Oh yeah, that's great. And I find that actually using that gut reaction to test that fairness threshold feels very, very important. So being fair is something that is quite subjective. But something that needs to be considered really on a case-by-case basis. Is what you're doing. So Helen, you gave a really great example there about biometrics for checking out car keys.
Car key, yeah.
I'm not my
And
fairness threshold.
I think this comes back to one of those other principles, isn't it? Is there a less intrusive way in which the same outcome could be achieved? And
Yeah,
if the answer
absolutely.
to that question is yes, is it fair?
Is it fair? Exactly. So, and I think that, do you know what, Helen, I'm so glad that you gave that example. That's a really, really great example to have shared. So that's the first one. Helen, do you want to reveal the second one?
Press the button again, reveal the second one. Limited purpose.
Okay, so and we'll talk about this a little bit in the next slide. So the GDPR is extremely useful in the sense that it actually tells us the purposes for which we can process data. So there's a really, really big myth out there that we can't do anything unless we have somebody's consent to do something with their data. And we'll talk a little bit more about that with the next slide. But there are a number of purposes that that the law allows us to process somebody's data under. And once you've set that purpose, you should really only continue to process that data under that purpose. It's not necessarily something that you should change. So it's making sure that actually when you've set that purpose, you know what you're doing, you know why you're doing it, and you stick to doing it. And you don't necessarily, we all see a little bit of scope creep in projects, but we're not necessarily allowed to do that same scope creep in data processing, are we, Helen?
No, not at all. So we had a good example of this last week, didn't we, with CCTV, our friend CCTV, where we were told about a case where somebody was collecting CCTV images just for the purpose of keeping their premises secure. So this was the outside perimeter of their premises to keep it from being vandalized or from external intruders coming in. The data from the CCTV was then used in an HR case, and we went, that's collecting data for and using the data for a different purpose for which it was being collected. So a good example there of just thinking about when you may be collecting data and the why you're collecting the data. Should we look at the next
Helen,
principle, Anna? Go on.
Yeah, just going back to that example actually, and that's really useful if we go back to that first box there and talk about transparency, because I would be fairly confident that the privacy notice did not tell individuals that the CCTV would be potentially used for HR purposes. So again, there would be there would be some changes to make that transparency before you want to change that purpose.
Okay, our next principle.
Okay, so data minimization. I do love these words, Helen. They're all very big, aren't they? So data minimization, put at its heart, is only use the data that you absolutely need. Only collect the data that you absolutely need for the purpose that you want to use it for. Helen, your key example is an absolute classic. So if we apply data minimization to the, do they need your fingerprints to release the car key to you? I would also be I would also be a little bit unsure about under data minimization whether they would need that. So you know, an example here is you know, from an employee health and safety perspective, you know, would you be needing to actually collect somebody's shoe size? If there was safety footwear required, then yes, potentially. But unless you have a requirement for somebody's shoe size, you should really be applying the approach for data minimization here and only collecting the data you absolutely need for the purpose for which you need it.
Fantastic. And I'm sure we've all seen forms where you look at the form and you just question yourself and go, why are they collecting that information? What are they going to use it for? Why do they need it? Perfect example of data minimization not being followed in those situations. Accuracy should be fairly self-explanatory, this one.
You really should. And actually, this is where data protection almost becomes quite common sense, actually, because if you're collecting data, why wouldn't you want to keep it accurate? It is fundamentally one of the principles of the GDPR, so we do have a legal obligation to ensure the data is accurate. And this is where it becomes quite interesting in terms of how you build this into some of the processes you may have within your organization. So when you collect it, it may well have been accurate. But actually, if it's data you're going to continue to use, do you have some regular check-ins in your processes to make sure that actually the data we collected 2 or 3 or 5 years ago is still accurate for its usage today? So you know, if I give you an example of how to do that, so for example, if it's customer data, you know, each time you speak to a customer, or you know, every 6 months, you know, when you have a conversation with them, say, can I just check that that email address I've still got for you is correct? So there's lots of really simple ways. It doesn't have to be a very, very complex way to keep data accurate. It's one of those things that we get asked quite a lot of, when should we do our accuracy checks? Well, just throw them into conversation. Just say, oh, by the way, I'm contacting you on this phone number. Is that still the right phone number for you to, for us to contact you on? So drop these kind of things into your everyday conversations, these accuracy checks.
Absolutely. Retention. Oh, we love retention, don't we?
Oh, don't we love retention? And Helen, do you know what? I'm sure we could do a whole session on data retention. We could. And I think, so I hear this question a lot, is how long does the GDPR tell me I should keep data for? Now, the GDPR, with it being a principles-based law, only tells us to keep the data for as long as we need it. Now, there are many examples that actually it's held within other laws, the rules on retention. So there are many other laws out there that will tell us how long we need to keep data for. So a great example here in the UK, our health and safety laws tells us that we need to keep certain types of accident data for 45 years. So that's it. That's how long that data needs to be kept. So actually, where you should be seeking the answer to the retention question is potentially within other different laws rather than GDPR. As long as you are keeping the data for as long as you need it, and you can justify robustly why you need to keep it for that long, then the principle of retention is being met. Helen, is there any other great examples that you could give to us here?
So again, another piece of UK law. We got UK law which says financial information is kept for 6 years plus the current financial year. So as Anna said, there are lots of other pieces of legislation and regulation that will point to how long you should keep it. If you haven't got a piece of legislation or regulation, you just need to justify it, don't you, in terms of the last. A good example I use is a birthday cake company may keep your details on file, for example, for maybe 2 years. If you haven't come back to them the following year, you have a birthday every year, surprise, surprise, if they can probably justify keeping that information for 2 years. But after that, it's a bit different. A fencing company, so somebody puts a fence up around your home, has got a lifetime, I'm told, of between 7 and 10 years. So there's justification for keeping information for mailing and sales purposes on their computers for a little bit longer than a birthday cake company. It really is, outside of legislation and regulation, up to individuals to determine what that retention period is. Providing it can be justified, and we would recommend writing down what that retention period is, you're good. You're absolutely good. If you have a supervisory authority that comes and asks you why, you just need to be able to prove it and to evidence it. So what's our remaining principle?
And so again, I think we're going back into common sense territory here, aren't we, Helen? The final principle that the GDPR gives us for the processing of data is actually to keep it safe. Applying good levels of security is crucial to the protection of that data. And think about security in a couple of ways. It doesn't necessarily have to be the technical security elements, although that does apply. Think about the physical security elements as well. So think about those locked doors, locked cabinets, and those kind of things. So I think there's a real tendency nowadays, isn't there, when we talk about the word security, to think about information security, InfoSec, multi-factor authentication, all those kind of things, but don't ever lose sight of the importance of physical security of people's data.
Brilliant. And then because we've got 6 principles, we've summarised those, haven't we, Anna? And I love this slide of yours. Just sort of quickly rattle through it. We've just summarised all those into sort of more plain speak.
Yeah, I've used this for a long time. Helen and I and the rest of the team are really passionate about making sure that these compliance things are a little simpler rather than all those big words that we find in the law. So if we go back to that first principle, this is all about being honest with people about what you're going to do with their data. And I've put there, don't be creepy. When we're thinking about what we might want to do with somebody's data, if we have that personal reaction of, oh, I'm just not sure, then we could be getting into that level of actually, are we being a little bit creepy here with what we want to do? Know your purpose, know why you want to do something with somebody's data. Only collect the data that you need. Make sure you keep it correct. Don't hoard it just for a rainy day, even though it's really, it can be tempting to do so. If you're not sure why you need the data, then you need to be really quite honest with yourselves. and actually go, do you know what, if we don't have a justification, then I don't think we should really be keeping it. And when you do have that data, remember it's being entrusted to you. So, you know, even if it's by employees or by customers, people are entrusting that data to you and expecting you to keep it safe. So keep it safe.
6 principles plus accountability.
Absolutely. I always like this because, you know, I always kind of think, well, we've had the 6 principles, but there is a 7th one, and this principle comes onto the organisation in the same way that all of you who work in health and safety are used to having accountability at the top level of the organisation for health and safety. The same applies with data protection. The ability to demonstrate how you're meeting these 6 principles is important. The business is accountable as a data controller for the processing of data and for meeting all of these 6 principles. So the principle of accountability also sits alongside these additional 6 principles.
Okay, so that's our principles summarised. Lawful basis. So we've got lots of 6 and another bunch of 6. This is the reasons why we can keep data. So we'll have a quick look at these. Some of these will be familiar to individuals, others may not be quite so familiar. So consent. I remember back in 2018, my in-basket was just full of people screaming at me, I need your consent to hold my data. What's all this news about then, Anna?
So, and I think this is one of our, we like to do a bit of myth busting, don't we, Helen?
Yep.
And I think this is often one of the biggest myths that we bust still today, actually. There is still quite an assumption out there that we must have people's consent to do something with their personal data. And whilst it is one of the lawful bases that applies, it is not the only one. And consent, we need to be quite careful as to how we apply consent, because consent can be withdrawn by an individual. So if we are relying on consent to do something with somebody's personal data and they then withdraw it and we have to stop, that could be extremely detrimental to the process. It may actually have been not the correct lawful basis to have selected in the first place and could be quite disruptive. So consent should only be used when absolutely necessary. It is necessary under the electronic communications regulations when it comes to marketing. So there are times when it is absolutely necessary for consent, but please make sure if you are relying on consent, make sure that actually it's being done appropriately. And I think the other top tip I would give you here as well is that think about the relationship that you have with that individual. So there are times when consent, if there's a hierarchical relationship with that individual, and the individual may feel forced to consent or else something else might happen to them, then again, be very, very cautious of that use of consent. It's very important in the world of employers and employees, isn't it, Helen? That consent is only used when absolutely necessary. Consent should be freely given, and it should be absolutely explicit. People should know what they are consenting to and for.
And there can't be consent dependencies on consent, is there? So I was on a website the other day and it said to me, you can only access this website if you consent to us sending you an email. No, that's not consent, that's the dependency. My consent, therefore, is not freely given. And certainly when we work with clients, we look at anywhere where they say that they're insisting on consent, and we just make sure that consent really is the correct lawful basis for processing, because we know that, as you rightly say, people can withdraw that consent at a moment's notice, can't they? And you have to respond accordingly.
Yeah, absolutely. And I think as well, there's another element that's just important just to mention is that consent for data processing can't be bundled in with additional contractual obligations, so such as terms and conditions and those kind of things. It must sit alone and it must be explicit.
Yeah. So happy to take any questions offline on consent, because this is probably the lawful basis that we spend most of our time talking about. There is another one we spend a lot of time talking about, but consent is one of them. Right, so that brings us nicely into contract. Okay,
so one of the other lawful bases is what's called for the performance of a contract. So if you need to, as an organisation, process somebody's data because you have a contract with them to deliver them a service, then this would be the most appropriate lawful basis to select. So great example here is, and I'm going to use your friend Mrs. Miggins here, Helen. You know, if Mrs. Miggins has ordered some fence panels then you would absolutely have a need to have her address, her name, and her payment details to be able to process that order, to process that delivery, and to process that payment. So you would be processing Mrs. Miggins's data for performance of a contract. Similarly, from an employee-employer perspective, there would be a significant amount of information that you would need to collect from your new employee to enable you to perform that contract of employment with that individual. So I think this is probably one of, sorry, Helen, go on.
It's an easy one. An example there is bank details, isn't it? Most employees, in my experience, like to be paid. So therefore, you need to have that data in order to, yeah, unfortunately they do. Anna. But yeah, most employers therefore that will provide you with bank details. You need that in order to operate your contract of employment with those individuals. So moving on.
I think the one thing I would just add to contract there is a threshold here that we must all remember. It must be necessary. The processing of that data must be necessary to perform that contract. And that's quite a strict threshold. So do really consider, is it necessary to, you know, so it would be necessary to have Mrs. Miggins's address. It wouldn't necessarily be necessary to have Mrs. Miggins's garden size unless you were fitting that fence post, those fence panels.
Okay.
Helen, I do love the fact that when we do these workshops, when we do these webinars, we often, you know, it's kind of unspoken, isn't it? What example we use, and it seems to be today we've picked fences for some reason.
Miggins, bless her. Yeah. Legal obligation.
Right. Okay. So moving swiftly on. The third lawful basis that we have available to us for processing data is because the law tells us to. So a great example here would be actually in the health and safety world. If there is an accident, then there is certain personal data, certain information that you must process in terms of your accident documentation, your health and safety documentation. So there are times when you will absolutely have a legal requirement to be collecting somebody's data. Helen, any other good examples you can? It's actually really quite a simple one, that one, isn't it?
It's a really simple one. Finance law is another good example where we have to collect data. So again, back to tax law, for example, we need to know how much we're processing, how much tax we're paying for individuals. That is enshrined in UK law. Certainly in the UK, again, we've also got right to work. We need to have evidence that individuals have got visas and the appropriate permits to lawfully be employed by a UK company. And I'm sure there's lots of other local examples that you can think about as well.
I'm gonna go there with a slightly different example of actually where a lawful basis might have more recently changed. So if we revisit the last few years for COVID, there were certain legal obligations for collecting data at that point. That might have been vaccination status, it might have been temperature, it might have been, you know, whether you've had COVID or not. However, some of those laws have now been repealed, so that data may not have the same legal obligation on it anymore. So if you do have some of that data, it would be prudent to actually make a decision as to whether there is a new lawful basis to have it and actually whether you should have it in the first place. So the legal obligation there is likely to have changed, hasn't it, Helen?
Yeah, absolutely. Good call. The next two we don't seem to see quite as often. Vital interest.
So vital interest is it's one that we don't use very often, but when we do, it is literally a life and death situation. So and actually in the health and safety setting, it's quite a useful one to talk about. So if you need to do something with somebody's personal data that protects their vital interest, in other words, it will protect their life, then you are able to do it under vital interest. So I will give you a situation. So let's say somebody has quite a serious accident and they're not in a physical state to be able to give consent for the sharing of data with medical professionals to provide that medical support. Then you would potentially be able to consider using vital interest for the sharing of that personal data, because the individual, you know, they're in a life and death situation, they've had a nasty accident, and you need to actually take the right steps to be able to share their personal data. You may actually be able to do it under legal obligation depending on what's happened, but you know, if you're not in an employment setting, and you know, I often get asked actually as a data protection person, what if I'm going down the street and somebody has an accident? Am I allowed to go through their wallet, their purse, to find out, you know, who I need to contact? Absolutely you can. Absolutely you can. So if there's ever any concern about doing something that will protect somebody's life, then you would be using vital interest to do that.
Public task, that's another one. We don't see it as often, although there are obligations, certainly in school settings. That's one where we have a public task, a public duty to deliver education. That, for example,
Yes.
is one. Personal information is reused for local authorities, so your government departments to, I don't know, empty bins, for example. So there are certain obligations and certain data collection that will take place in order for companies or in order for organisations to fulfil their public task. Again, not one we see particularly often, is it, Anna?
No, it isn't. And actually, an organisation relying on public task as a lawful basis should be an organisation that is designated as a public organisation as well. It's not something that would be available to, potentially to corporate organisations.
And then finally, our catch-all bucket, which does generate a lot of discussion, legitimate interest.
Yes. So if any of those 5 lawful bases don't apply to what you would like to do with somebody's data, then we do have the opportunity to consider legitimate interest. Is what we want to do in the legitimate interest of the organisation and doesn't outweigh the rights and freedoms of the individual's data who we want to process. And there is, I mean, Helen, just like data retention, we could do a whole session on legitimate interest, couldn't we? And I think the one tip I would use here, while it's not necessarily mandatory under the GDPR to do this, it is highly recommended. Those of you, you know, we're in the health and safety setting here, so you will be familiar with risk assessments. There is a risk assessment that can be done called a legitimate interest assessment, an LIA, which actually walks you through the process of understanding, okay, so why do I want to do this with somebody's data? You know, what is the risks to the individual? What is the benefits to the individual? And it allows you to walk through and document that thinking process. You know, a great example here would be, you know, certain types of management information. You know, there's lots and lots of statistics and analysis that a business has to do, and some of that may require the processing of personal data, and it would be entirely it would be entirely legitimate to use legitimate interest. Ooh.
Sorry about that.
That's okay.
Click the keyboard inadvertently. Legitimate interest we also see being used for some marketing purposes, don't we? But again, it's that balance, that assessment to ensure that it's in balance with the employee or the individual is absolutely key. And we don't just go off and decide that because it doesn't fit into one of these buckets, we're going to use legitimate interest. And I guess that's the other key point, isn't it? Is if your data processing does not fit into one of these, very simply, you cannot process the data.
Cannot do it. Yes, absolutely. And you need to be honest with yourself about that. If we go back to that first principle of you know, be honest, it's not necessarily just being honest with the data subjects, be honest with yourselves as well. If you are struggling to kind of squeeze that in and think, oh, I don't know, but I really want to do it, proceed with very extreme caution, and you really mustn't be doing something if you've got no reason to be doing it.
Right, I'm conscious, Anna, that time is marching on, and we now have 8 data subject rights to go through.
Yes. So I mentioned right at the beginning that data privacy was a human right, and the law actually gives us 8 very specific rights. The GDPR gives us these 8 specific rights, and we'll just briefly go through them. And so I'm kind of telling you here, almost to put your own consumer hat on, put your own hat on here, and these are the rights that you have as an individual. So you've got the right to be informed, and that is the right to be informed what an organisation is doing with your personal data. And if we align that back with the principles, we have the principle of transparency. So the organisation has an obligation to be transparent with what they're doing with your data in order for you to be informed under your data subject rights. It's quite an easy one, that one. So the next one is, oh, Helen, we have a lot of this, don't we? So we also have the right to access copies of our personal data. Now, this is often known as a subject access request, and is probably the right that is exercised the most, isn't it, Helen?
Absolutely, absolutely.
Absolutely. Again, we could do a whole other session on subject access requests. It is a very wide topic. The one thing I will say is that many of these rights, while we have the right to ask them, they're not necessarily absolute rights. So if somebody does ask to see a copy of their data, they are absolutely able to ask it, but it doesn't mean to say you have to disclose everything. The laws have a number of exemptions that apply to some of that data that may well actually prevent you from disclosing it. So if you're ever in a position where you have a subject access request, it's really important to make sure you understand you go through the process of understanding what is and isn't disclosable.
And I think it's also important to remember here as well, isn't it, Anna, that this is personal information we're talking about. This isn't company information. So if your name is mentioned at the top of every single email that you've ever sent within an organisation, that doesn't mean that you have to provide details of copies of every single email that's ever been sent. It's just personal information about the individual, not necessarily operational data. But as you rightly say, subject access requests, you have to respond within 30 days of receiving a subject access request. But again, as you rightly say, we can probably spend a whole session on that. And we've got the session again next month when we can go into it into a bit more detail.
Maybe we'll do an extra couple of slides about that, because I think it's quite an important topic.
Rectification.
So rectification. So if we align that with the original 6 principles, we have the principle of accuracy. If our data is not accurate, an individual has the right to ask for rectification for that data to be corrected. Similarly, then, if we are found to have data that we shouldn't have as an organisation, an individual has the right to ask for the erasure of that data as well, often known as the right to be forgotten. But again, be mindful here that they have the right to ask, but there is, depending on the lawful purpose that you have the data. So let's say you have the data because you have a legal obligation to have it, then you should not be erasing that data, because actually you would then be in breach of that legal obligation. So again, it's very important to understand the lawful purpose for why you have that data when you're considering an erasure request.
And that goes back to one of Alison's questions, wasn't it? In terms of, can an individual ask for any data that's being collected on them about an accident? Probably not, is the answer to that question. So just be mindful, understand why you're collecting information, and do not delete it if it's therefore to fulfil another legal requirement.
Absolutely.
Again, we can probably talk about erasure, because we're seeing quite a few erasure requests coming through, and actually erasure is a really interesting one, isn't it? Because you can ask any company in Europe to delete data about you. So yes, lots of time spent with erasure requests at the moment. Portability, this is another interesting one as well, isn't it?
So portability is so while those rights that we've just mentioned, they were actually already in the previous data protection laws before we had the GDPR. One of the new ones that the GDPR introduced was the right to data portability, and that is the right to take data with us if we move to a new service. Now, some industries already do this. So certainly here in the UK, the energy sector already do it. So if we move to a new energy provider, the data is transferred with that move automatically. Now, it's the difference here between the right to access and the right to data portability is quite subtle, because, well, you know, if you want your data to move to a new service, why don't you just put a subject access request in? So a portability request only covers the data that you originally gave an organisation in the first place, but it also comes with an obligation to actually, for the organisation who's received a portability request, to potentially consider sending that data to the new organisation as per the request of the individual. I will say it's one that we don't necessarily see being used very often, is it? I've not actually seen any examples other than the ones that already happen within an industry like energy, banking, the health profession. I'm not seeing what it's a right that's being exercised a significant amount. I don't know if you're seeing that, Helen.
No, the only time I've ever seen it was with a lady that measured hats for horse riders. So she actually took a physical measurement and she wrote it down on a piece of paper. She had a request for portability because the individual for whom she measured, took those personal measurements, wanted to go and buy the product off the internet. In that instance, right to portability only applies to digital data. It does not apply to paper data. And because this lady had written it down on a piece of paper, she was therefore exempt from doing that right to portability. That's my useful story, perhaps, but nice differentiator.
Interesting one.
Restriction of processing.
So if now the right to restriction is a very temporary right. So if we want to stop an organisation doing something specific with our data, we can ask them to restrict that processing. However, it is only a temporary measure. It must have an end date. So, you know, a good example here would be potentially in a debt collection scenario. So if an individual finds themselves in debt and being pursued by a debt collector, if there is a concern about the accuracy of that debt, then you can ask for subject access request to find out the data that they have and understand the data and how that debt was calculated. And while that is going on, you can certainly ask for a restriction of processing while the accuracy of that data is being checked. And then if we're using our rights in a really, you know, strong way here, we can then, once we find out, let's say that we find out in our accuracy check that the data was incorrect, the debt was incorrect, we can then ask for a rectification request and then lift the restriction of processing. So that just shows, that whole process there shows how important it is for us all as consumers to understand the rights that are afforded to us.
Okay. We can object to automated decisions as well, can't we?
We can. So if we are subjected as individuals to an automated decision, so the example of this would be we're applying for a new credit card, you know, we enter all the data and we have that last little wheel that goes around that says, well, just computer's making a decision, and it comes up to say no. We have a right to object to that and actually ask for a human review of that decision. So really, really interesting one. And actually there's some very interesting case law that I think is going to be coming out. I don't know how far we are into it, but there is some cases going on in Europe in relation to credit scoring and the impact that the automatic generation of credit scoring impacts on automated decisions being made about us as financial consumers. So one to watch. I'm not really sure where we're at with that, but I know there's a couple of cases going on about it at the moment. Okay. So I think there's probably quite a lot of water to go under the bridge with that, because automated decisions are being made about us all the time in many, many ways, you know, with the growth of AI and that kind of thing. So yeah, interesting area of work.
And final right, we can object to the use of our data as well, can't we?
We can. If we want a company to stop using our data, and this applies especially in the marketing world, we can object and say, absolutely, I want you to stop doing that. However, it doesn't apply. Let's put the debt collection hat back on. It doesn't mean to say that you can actually say to a debt collection organization, I object to you doing that, please stop. You would have to have a strong reason for doing it, and for that reason to be, you know, to apply to that use of your data.
And that's where we're actually seeing a number of complaints coming through, certainly from a supervisory body in the UK, is where mailing companies are just not taking people off mailing lists, for example, or they're telephoning people and so on and so forth. And this is where some of the links fit in with the e-privacy, and certainly from a UK perspective, the PECA regulations as well. But again, we can probably do a whole session on objecting to data. So what's our top tips for our callers and for our listeners on this call then, Anna, and then we'll open up hopefully to some questions. Okay,
so I think we're always conscious in these sessions that we've almost bombarded you with so many things. Even in those last 3 slides, there's quite a lot to take in there, and you know, we're always aware that you know, you're probably sitting there going, well, what can I do? What are the things that I can do? What's the quick actions that I can take to understand our position on this? So these are the 5 questions that we would recommend anybody to take away with them. So go and look at what data you have, whether that's within your team, whether that's within a section of your business, whether that's within the business as a whole. What data do you have? Understand why you have it. Make sure that actually there is a good lawful purpose for you having it. Where is it? Is it safe? Now, again, this is probably one that we could do a whole other session on, Helen. Understanding where data is that nowadays can be quite tricky. Unlike us, when we travel, we need passports to go across borders, don't we? Our data does not necessarily, it doesn't need a passport and can travel within milliseconds across multiple borders and end up in lots of different countries. So understanding where your data is being held is really important, especially if you're using cloud services. How can you do that? Have a look at the organization's privacy policy, because they have an obligation to tell you what they're doing with their data, and there should be a section in an organization's privacy policy that talks about data transfers. So know where your data is, know how they're keeping it safe. Make sure you're having a conversation about how long are we keeping it? Do we know how long we're keeping it? Do we have that retention schedule? Do we understand? And do we actually even having the retention documented, are we actually then following through with that and actually deleting data when we no longer need it? And then think who you share it with. Who are you sharing data with on a regular basis? That might be people within the organisation, it might be other organisations, it might well be other third parties such as your cloud providers. So asking who you're sharing that data with, and actually how long have we been sharing it, and do we still need to keep sharing it? So these questions can grow and grow, Helen, can't they? But these are the 5 top tips we would give you to kind of go away and, you know, pick one a week. Just go, right, okay, next week I'm going to look, what data do we have? I'm going to make sure I'm confident that I know that.
So we've done a whistle-stop tour through principles of the GDPR, principles of privacy regulations, certainly in Europe. We'd be delighted to take any questions. We do have a separate session that's planned for next month as well. If you go away from this and think, oh crumbs, I forgot to ask a question about that, then obviously please reach out and ask questions on that call. Alison, I'm going to hand back to you now.
I have the questions in front of
your questions.
And please keep sending them. Firstly, are there examples of case law specific to health and safety holding data? So case law where someone has been prosecuted and fined for holding.
We didn't talk too much about the fines. We didn't talk too much about the fines, Alison, and that's because if you're doing the right thing, in the majority of supervisory bodies across Europe, the chance of fines is unlikely. Now, there's a big caveat around that, because obviously I said if you are doing things correctly, then I've not seen any specific case laws. I have seen cases go through where individuals have been fined for accessing data that they do not have authorization to access. So this is typically in a healthcare setting where somebody's decided, I'll be quite interesting just to look up the healthcare records of a friend. That is against the law. And in those instances, I'm very happy to share with anybody on this call, they are in the public domain where the supervisory body has taken action against those individuals. But I'm not familiar with any case law, certainly from a UK perspective. Anna and I do monitor European case law as well, where there have been cases outside of the UK where there's been prosecutions in that space.
Okay, interesting. From a health and safety perspective, imagine you're doing a site inspection and you see someone working unsafely and you write down their name and you take a photo of them. Are you allowed to do that?
Absolutely. Health and safety law trumps. In this instance, you're there to protect the rights and freedoms of the individual in a slightly different way. But yes, why wouldn't you? That's doing the right thing. Yes.
Definitely.
If you then have to fear then what you're going to use it for. But yeah.
And I think what I would also say is if that has been taken, let's say on a personal device, then what I would say is you do what you need to do with it to report that incident, and then you remove that. You make sure that the data is held safely and securely and given over to the individuals who need it. And then I think it's then a consideration as to whether you would personally need to keep that. But as long as you've transferred that data to the individuals that need to have it, then certainly just be aware that especially if it was on a personal device, let's make sure that that's removed.
Okay, is this everywhere? Because if you go somewhere in Germany into a factory, they are really keen to take your phone off you because they don't want any photos. Now, I guess part of that is their product development and things, but also the data privacy aspect of it. Is it stricter in different places?
Certainly I see, we've got a couple of clients where it's exactly the same, Alison, and you're right, that's not so much a privacy, that's more around an intellectual property. They're protecting the assets of the company.
It may also be a technical requirement, because it may well be that the signals from the phones could be interfering with some of the electrical equipment that's in the factory as well. So there's lots of other reasons that could be being done.
Okay. How do you destroy data?
That's a good question.
That's decided.
No, well, I think we were going to do it depends.
It depends. Yeah. One of the phrases that Anna and I use most frequently when we come to privacy is we say it depends. So obviously it depends on the type of data and the format that data is in. If it's on paper, shred it. Don't just chuck it in the bin, shred it. If it's digital, then there are various technical measures that you can use to make sure that data is absolutely gone. If you are sharing data with a cloud provider, then one of the things that the regulation asks for is that those cloud providers give you evidence that they have deleted the data or removed the data from their systems.
I think the one thing I will add to that is, because I'm sure there'll be somebody out there thinking, but what about my backups? So when it comes to data in backups, that can be a little trickier, because actually the deletion of data from backups can render the backup not non-usable. In that case, that's a conversation with your team who do your backups to understand what's possible there. In that case, if you've deleted some data, it is still important to make sure that if you're not able to delete it from your backups, if at any point in time you need to bring your backup back into back into a live scenario, that you're able to then repeat the deletion before that data then goes live. But the area around backup is quite a tricky one, isn't it, Helen? But be very aware that actually the deletion of data from backups could render your backup non-usable. So have a conversation with your IT provider, with the team who do your backups, to understand what's possible there.
I guess you're trying to remove small parts of data from a big amount.
Yeah.
So I've, for example, been to a factory where they were deleting hard drives. That was their role, and they were overwriting, and then smashing everything up. But that's like the whole drive. That's not just removing someone's name because they've asked for something to be removed.
And it's really important as well, if we go back to the original principles, think about the reason why you have it in the first place. Think about what type of data it is. Is it really highly sensitive data? And think about the proportionate measures. What is proportionate to, because like you say, Alison, there are organizations out there are different protocols for the type of deletion, depending on, you almost get the military grade level of deletion, but what's proportionate for the data that you're trying to delete.
I certainly still get junk emails. Is there anything I should do about it? And the really annoying ones, they've got unsubscribe at the bottom. You click it and nothing happens. And actually, probably that's some sort of phishing thing.
It could well be.
Or
so you can write back. So you've got a right to complain in that one, Alison. If somebody does not remove your, and funny enough, I've got one of those going on at the moment, where an individual keeps posting stuff to me. Now I've asked them 4 times to remove them from their database. I have this great big thick holiday brochure that drops through the front door once every 6 weeks. It's a waste of money. It's an environmental impact. And do you know what? I'm now going to the Commissioner's office with a formal complaint for that, because they should remove you within a reasonable period of time. Reasonableness is usually 30 days. Just complain.
Yeah, absolutely. And I think if you're not sure as well where to complain to within the organisation, because those unsubscribe buttons, like you say, might not go anywhere. So go and have a look at the organisation's privacy notice on the website, complain to the data protection officer. If you get no response from them, then it is absolutely time to go to the regulator, whether that's in the UK, the Information Commissioner's Office, whether in France, it's CNIL. There will be different places to go to.
Yeah, I was going to say it's usually in a different country, isn't it? And probably not in Europe. But if it's not in Europe, is there
in which case, yeah, it's not brilliant, Alison. Just mark it as junk and let Microsoft Outlook, etc., take care of it.
Okay, right. Thank you very much. Those are the questions that. Oh, hang on. Sorry, I have another couple that have just come in. What effect has opting out of the EU had on the applicable UK law?
Well, we've got adequacy. So the UK has got adequacy with the EU. whilst we have our UK GDPR now, which is pretty much the same as the EU GDPR, we have to have laws that are commensurate or better than the EU's in order to retain that adequacy. So whilst we know there's lots of speculation about future changes in UK legislation, at the moment we are continuing the UK GDPR and the UK Data Protection Act.
Yeah, there's been no divergence yet, has there, Helen, at all? We are very much still aligned.
Okay, and the last one, you mentioned health and safety accident book. If an individual submits information for the book, is this automatic consent? They have willingly surrendered the information, or should it be explained within the book before they fill it out? Could induction training be used to ask for consent for this? Does the consent have to be documented?
Shall I go with this one, Helen?
Yeah, you go with this one because it doesn't feel like a consent thing to me, but carry on, Anna.
So if we go back to those 6 lawful bases that we have available to us, consent is one that should only be used with real caution and when necessary, because if that individual withdraws that consent, then you would potentially have to consider taking that data out of that book and potentially erasing it. You are collecting the accident data because you have a legal obligation to do so. So it is not, in my mind, I'm sure, Helen, I'm sure you'll agree here. You have a very different lawful purpose, and it will be that of legal obligation, so consent does not apply. However, the one thing I will say is, if we go back to the principle of transparency, make sure that that's included in your employee privacy policy and that they know why that is being done, and by all means cover it in induction, but make sure that everything that you're going to be doing with an employee's personal data is well documented in their privacy policy and explained to them, and potentially, yes, at the time maybe there is a little note in your accident book that says, you know, just to confirm, you know, the reason why we're collecting this is because we have a legal obligation to collect this data under, you know, by all means list that law and let them check that themselves. But consent feels like it would not necessarily be the right lawful basis to choose for the processing of accident data.
But I also wonder whether having a big, long privacy policy that no one reads is also the best way to share that information.
And I love a good privacy policy. I'm a bit of an oddball. However, the law is really useful here because it actually does say that we need to make privacy policies really easy to understand and accessible. So we can actually, one of the things that I do, if I'm drafting a privacy policy, one of the things I'll often do is put almost a friendly dashboard at the beginning with, you know, some little pictures and icons and brief text around what I think the individual will feel most, you know, feel like they most care about when it comes to their personal data. And then it's backed up in the background with something that they can almost in a layered approach, so that they can click on it and go, well, actually, I want to know a little bit more about how you process my accident data. How does that work? And they can click on something and it takes them a little bit deeper into a policy. So the policies should not be lengthy. They should be written in a really easy to understand way and quite simple.
Oh, that sounds like all our dream, doesn't it? Think of all those big health and safety manuals. But
yeah.
Anyway, we've come to the end of the time. So thank you very, very much. Yeah, no, I've learned a lot. I found it very interesting, and I hope that other people on the call have as well. And I'm looking forward to the next one. So please, everyone, join us. The date is it the 21st? Do you know the date of the next one?
Yeah, exactly.
21st of March. Great. In that case, everyone, please register for that, and we shall continue. Thank you, Anna. Thank you, Helen. And goodbye, everyone.
Much.
Thank you, Alison. Just to let everybody know, the event will be available for booking in the next day or two. Thank you for Helen and Anna, and also Alison for hosting the event today. We're getting some compliments in. Amazing. Thank you, Guru. Thank you. Really helpful.
Yeah.
You've got a new name now. That will stick, Anna, I'm sure.
That's going to stick, isn't it? Oh. It could be worse things I could be called, I guess.
Yeah.
I hope everyone has a good afternoon or a good evening wherever you are in the world, and we hope to see you at the next Europe Branch webinar, which will be on the 21st, and it'll be at the same time. See you next time.
Great.
Bye, everyone.
Thank you.
Have a good day, all.
Thank you, everyone. Bye. Does the recording stop now? That was brilliant.
Is that okay?
Does the recording stop? Yeah, on Zoom it's got this big red button, but I don't know how this one works. Anyway, I presume it stopped. That was fantastic. Yes, really interesting. And I love the way the two of you talk together. It actually makes it much more interesting and entering a conversation rather than having death by PowerPoint. So that was really good.
Yeah, no, we try and use examples, Alison, just to bring it to life. We appreciate this can be, and we don't believe it is, but we believe, you know, we appreciate that some people think it can be a really dull topic, so we try to get around that.
It's a difficult topic. I mean, it's the same with health and safety when you're talking to people who it's not their day-to-day job, and you're telling them about foreseeability and those sort of issues. And this is exactly what you're talking about. Sorry, I was reasonably practicable is the one that you know, is it reasonably practicable to do this? And you're saying very similar.
Yep, absolutely. It's exactly the same.
Job. It's quite difficult to know where that line is.
It is. Right.
Yeah,
and Alison, if you get any other feedback, then obviously Anna and I will be very happy to process. And if there's any particular topics that you'd like us to cover in the next session, then equally please shout.
Yeah, we'll get some questions to you, and you know, you probably know the best questions, and then we'll add a few more in. And yeah, so what are you thinking, that it's more of a discussion next time? What are you thinking?
I quite liked, yeah, I was saying that it'd be great to have a a health and safety person on the call as well. And we just talk through some scenarios, perhaps, as you say, where we've got an accident investigation and then followed by a subject access request, something like that. What information can we share? Some scenarios, Alison, something that's causing your members to go, well, what would we do in that scenario?
I think
they've had instances.
So my feeling is it's more the big companies that worry about this. My husband is great at saying that the legislation is targeted for people like Facebook, who are, you know, how you're on Facebook and the adverts come up are so freakily. And I had one where it said, I had a Polish dentist in the UK, and I had a friend request from him. Like, now he hasn't sent me that. That's just a, have you known, this person? How on earth do they? That's my dentist. It's, you know, so my husband certainly thinks that it's more targeted at that rather than small companies who, you know, we're just sort of toddling along. Would you agree with that, or?
I think my view is it depends where you are as well, Alison, in Europe. If we look at the litigious approach that we have in the UK, then unfortunately we are seeing litigation in the UK against companies, doesn't matter the size of the business, where there's been data breaches. We see, I mean, Anna, I hate to say this, because typically whenever I say it, we then get another 3 or 4 come in. Anna's been dealing with a subject access request every week of the year so far. So, and those are aimed at small businesses, those are aimed at charities. So whilst the legislation may have been designed with the likes of the Facebooks and the Googles and goodness knows who else in mind, the reality that everybody in the supply chain has to abide by exactly the same piece of legislation.
Yeah, so it's not so litigious here in Switzerland. For example, I work with a university here, University of Zurich and University of Warwick. University of Warwick, the amount of claims they have for people falling down holes and things like that, and they're really keen on you know, we have to really make sure that we have no holes, kind of thing. Whereas here in Zurich, he said in the same time period he'd had like 3. Like, it, you know, it just doesn't happen. People don't fall down a hole and then sue the university.
We're actually,
I don't know if it's a similar approach.
We're certainly seeing an increase in you know, the litigious claims. So, for example, I mean, I've got you know, quite a sad case at the moment of a small manufacturing company who had one of their members of staff fell victim to a phishing attack, and we're fighting off now over £35,000 of compensation requests because of that simple data breach. So you know, the impact of things like compensation is actually, when there was a question about the fines, And actually, we're not necessarily seeing the impact of fines. We're seeing the impact of actually data subjects understanding what rights they have, and the right to compensation is built into the GDPR. So it's understanding how those apply and what the risks are of those.
Oh, and what sort of information did they get? Was it just names and emails, or was that medical information they got?
Yeah, well, then that's the thing. So it's name, email address, and physical address, and that was it. So most of that is in the public domain anyway. But it doesn't
very
stop.
much at all.
No, but it doesn't stop the claims coming in, and they have to be handled.
And how much is each person claiming for? Is it like a class action where they all come together?
No, it's not a class action, and it's anywhere from £750 up to, I think the biggest one we've had was 5,000. They're not being paid.
For just for your name and address.
Yeah. Just for your name, address, and email address. So,
but it's sad for companies. I don't know. Maybe this is not the right way to look at it. You know, when you're going through money, there's the option to, and no one has any money to get some money that way. You know, I'm sure they're not actually that worried about their name and address being made public, because I mean, it's actually pretty easy to find out someone's name and address and email address, isn't it?
It is nowadays.
Even if you go on LinkedIn, for example, you could. Yeah. A number of people have got it. Yeah. Anyway, great. Thank you again. Do you have any questions? Do you have anything? How are you feeling it went?
All good. All good, thank you. Just interested in any feedback that Julie or yourself may get. So, because we always look to try and improve these sessions. Do we talk too much? Do we not talk enough? Do we use too many examples? Not enough examples? So, yeah, any feedback is good feedback.
I liked the slides. The slides were simple. They didn't have like photos all over them, and it just made sense. It had a really strong and simple message going through for a complicated subject. So I guess that would be my because I always see, like, I've got photos and the photos are coming on and going off and whatever. So that was good. Yeah.
Okay.
I find it a bit freaky, Anna, that you have like someone creeping up behind you. There's this like black. I don't know if you can see it on your it's your chair, is it? But that looks kind of like someone's like.
It's
so that's interesting, because you managed in this platform to get a background, whereas I think I couldn't get a background in this platform.
Ladies, I'm going to have to.
You know, I use it for Zoom and for. Okay.
Yeah, bye,
anyway, thank you again very much, and yeah, I'll see you in a month's time, but we'll talk before then.
Thanks, Alison.
Okay, thanks. Bye bye.
Take care. Bye.